calling this important hearing. After a company files for Chapter 11, employees risk, as we all know, losing their livelihoods, health benefits, pensions through no fault of their own. These are things that workers have worked hard for and have earned. I'm going to focus, I think, the nature of my questions on you, Professor Jacoby. This issue has become relevant in a big way in my state because just last month, Yellow Corp, one of the largest LTL carriers in the country, filed for bankruptcy. This bankruptcy jeopardizes the livelihood and health benefits of many hardworking Minnesotans, including 480 Minnesota Teamsters. Do you agree that it is important that the bankruptcy process protects workers, including collective bargaining agreements, wage claims, health benefits, and retiree pensions?
Yes, I do, Senator, and I certainly think that was an animating force of Chapter 11 to begin with, the idea of allowing companies to restructure to provide worker protections, to save jobs.
And how are the interests of a bankrupt company's employees currently treated under the bankruptcy code, and how would you improve bankruptcy protection for workers?
Well, one thing that I worry about is that workers can be used as a justification to ask for things that aren't actually in the bankruptcy code. Very quick going concern sales and other kinds of deals, and often that's premised on saving jobs, that this quick sale will save jobs, that agreeing to a loan at a very high interest rate will save jobs, and yet there's often no guarantee. It's often not in the, if we read the fine print of the sale agreement, there may be no guarantees. So I think there should be more examination of what happens to jobs and the quality of those jobs in that kind of scenario. And I think we need to look at employment as well as in the union context, given so many of the companies that file for bankruptcy may not be unionized.
Mm-hmm. Right. So are you talking about changing some of the provisions in law then?
I think that could be warranted. I think it also makes sense to continue to look at what kind of protection is given to worker claims. There are certain priority claims in the bankruptcy code that often it's suggested could be updated to give increased protection, and sometimes, in some cases, even those administrative priority claims or other priority claims are not honored as they should be. So I think that should be looked at too. Mm-hmm.
So the U.S. trustee, a component of the Department of Justice, which is tasked, right, with overseeing the administration of these bankruptcy cases. So the trustee plays a really important role in bankruptcy proceedings and represents the interests of the public. This often means ensuring that the interests of a debtor's unsecured creditors are represented. How can Congress work with the U.S. trustee, it's a different way to do this, to ensure that the interests of employees and pensioners are properly represented and protected during reorg?
So the complicated job that the government watchdog has, which is what essentially the U.S. trustee program and the Department of Justice is they're supposed to appoint a committee that speaks for a full range of creditors, and yet we know even within a mass tort case, the creditors are not on equal footing. They may not have equal strength of claim, so it's hard to have one for another. We expand that when we're talking about workers, how to make sure a committee is properly representative of those who need protection. If the committee does not incorporate the full range, what other mechanisms can there be to get the constituencies a seat at the negotiating table? Because bankruptcy is supposed to be about that collaboration. They need a seat at the table.
And how could the bankruptcy code be improved, this is my last question, to better ensure that harmed consumers are respected during the restructuring negotiations? And you talk about victims as well in your testimony.
Sure. Well, I would love to think about that a longer time, and I'm happy to follow up with you. I do think that in terms of individuals, real humans, your constituents, who find themselves in a bankruptcy and say, what am I doing here? They need more of a voice in the process, the concept of procedural justice, that the process has to seem fair, independent of what the outcome is. And I think maybe many of us, I won't want to speak for anyone else, could agree on that, that there's more that the individuals that can be done to recognize their individual voice, because they are not a mass, even if there are a lot of them. They are individuals with very different situations, and we need more recognition of that during a bankruptcy. It's not enough in a mass tort case to have that in a trust afterward. Those are private organizations, essentially, and very hard to see what's happening there. We need more procedural justice during a big Chapter 11 bankruptcy case.
Okay, thank you.
Thanks, Senator Klobuchar. Senator Kennedy.
Thank you, Mr. Chairman. Mr. Haas,